So I just want to thank everyone for being here tonight to listen in about this very important topic when it comes to keeping your affairs private, because if you've been in business or you're considering getting into business, one of the aspects of running your own business that many business owners have conveyed to me over the years is that they wish there was some way to keep their affairs more private. That is, they want to operate in an environment where it's a need-to-know basis, not a need-to-show basis. That is that when you're out there and you're running your business, you don't want any person that you've dealt with to be able to get online right away and pull up your personal information, find out about who you are, where you live, who you're married to, how many assets you have. I mean, that's just stuff that we want to keep private as individuals. But the problem is that when most people go about creating their businesses or taking title to assets, they're typically not told about ways in which they can keep these acquisitions private, keep the existing assets they have private. That is, if somebody went out there and did a search for your personal information, this would not show up under your name. And the reason that is that most attorneys that you deal with, or CPAs, they just don't think in these terms. They'd often say to you, why do you want to keep your affairs private? Do you have something to hide? Are you going to involve yourself in some type of criminal activity? Of course, the answer to that is no. It's just that why do people need to have this information? That is that if I don't want to show it, then there's no reason that it should be out there for the public's consumption. And so one of the principles that we operate under when we're structuring individuals is that, yes, you can have this information publicly available. And if you go about it in the traditional method, it will be. And if you're comfortable with that, that's fine. Put it out there. However, there are alternative ways in which you can structure yourself so that this information is not available to the public or somebody with a computer so they can readily find this out. Now, keeping your affairs private, from an asset protection standpoint, I was just asked the other day by somebody who's considering creating a Nevada-based entity. They said, as far as asset protection goes, Clint, how much protection does this privacy give me? Well, when we're thinking in terms of asset protection, privacy gives you zero asset protection. So let's just get that out there right now. There is no asset protection that comes with keeping your business affairs private, keeping your name off of your assets. It's a smokescreen. That's all it is. And it's designed to keep prying eyes out of your personal affairs. That's all it is. Because you think about it in these terms, that if somebody was considering bringing a lawsuit against you, and this attorney generated his money based upon whatever he can collect, well, the first thing he may want to do is go out there and perform a background search of you individually to see what assets you have. If he can't find anything, then the likelihood that he's going to follow through with that lawsuit and taking on that client where he bears all the costs, all the risk, because he only gets paid if he collects, has been greatly diminished. So we look at privacy as a smokescreen. That is, if they don't know what we have, then it lessens the likelihood that somebody is going to come after us with two barrels and push us into court on the off chance there may be something there for us at the end of the day. And so this client who was asking me about privacy said, well, then what good is it? And I just explained what I said to you. I said it keeps the lawsuit from occurring. But if it does happen, so be it. You will have other entities in place that if they break through your smoke screen, they will then be up against an impenetrable wall that will prevent them from gaining access to your assets. And a good example of that is a case I was involved with one of my clients last year, where a bank that he'd been dealing with for years decided to pull $2.5 million of his money out of his account because they were concerned about a loan. Well, my client woke up one morning to find $2 million was gone that he had on deposit with this bank. Now, he subsequently sued the bank, and he was able to get those monies back because the manner in which the bank went about taking his funds, which if some of you on this call, you may not be aware of this, that when you're dealing with banks and you have loans with those banks, you've pledged all of the assets you have on deposit at that bank as collateral for that loan. So when you're thinking about dealing with certain banks and you're financing real estate, be very careful that you do not want to leave a lot of assets on deposit with that bank, because if the bank is concerned about their collateral. They can then take that cash from you and use it to pay down your debt. In fact, I met with somebody just last week in my Las Vegas office, similar situation that he was dealing with. So anyways, this bank took the money. We got the money back, and then the bank turned around, foreclosed on the construction project, and then went after him for a deficiency judgment for about $5.5 million is the judgment, or $5 million, somewhere around there. Well, this individual had a smokescreen created around his assets, and the bank's attorneys could not determine where the money went that the individual received back from the bank, which the bank originally stole from him. They couldn't find it. They couldn't trace it. They couldn't find any other assets in his name besides his personal residence. So they originally came after him for $5 million. They were beating the war drums. They were going to get this money, and then they couldn't find anything. They started sending out requests. What happened to the assets? Where's the money? And they were going to bring him in for a deposition, and he was going to be deposed. And so it was decided that in the interest of expediency, the client would disclose to the bank, how he was structured and how his assets were held. So he chose to pull back the curtain, blow away the smoke screen, show him that he had these assets, but they were held in entities that made it extremely difficult for the bank to collect against them, so he wouldn't be able to get the assets. That case did settle. It settled for significantly less than what the bank was entitled to. And we look at that as an example of, by using entities and using smokescreens in these manners, you're able to protect your assets from your creditors. And if you choose to settle, that is your choice, and you can then give yourself significant negotiating power in that type of situation. So keeping your affairs private is really important, and I'm going to give you a few strategies tonight on how to go about doing that, because I've seen it many times with my clients, even with my employees, how important this is. So lack of privacy. Anyone with a computer can find out where you live. That's pretty simple now. There's a multitude of sites out there where you can search somebody's information. Just type their name in, and it'll pop up with their address. And there's some paid sites that you can buy into that will provide very detailed information, where their previous addresses, where they used to reside. So, that type of information, whenever you use your personal address on things, you're letting the world know, hey, I'm associated with this. And this is where a lot of people do not understand how privacy works, is that they will have their personal address. They'll use it as their business address. They'll use it on the address for all of their tax statements for their real property. So everything can be traced back to you as an individual. So even if your name doesn't appear on something, such as, let's assume that you created a land trust and you used what I'm about to show you with the nominee trustee, but then you threw your personal address on as a place to send the tax statements. You may think that you have anonymity, but somebody, if they were diligent enough, could trace that asset back to you just through the tax statements, because the addresses match up. That is, your personal address is right up there on the deed or with the tax assessor, where tax statements are being set. So that's something to keep in mind when we're looking at privacy, which address you're using. How to locate your real estate. When you take title in your own name, you're letting everyone know that you own this property. And the problem that I have with that is that if something were to happen and a judgment was entered against you as an individual and your name's on the real estate, well, do you know that you're making it very simple now for a creditor to come in and slap a lien, of course, or a judgment, file that judgment in the county where your property is located. And if you ever try to refinance that property, if you ever go to sell it, then the creditor who has filed that judgment in the county where your property is located will now get paid off. And the only way you can prevent that is to ensure that the property is not in your name, because the judgment is against you as an individual. And so any property that is sold with your name on it as the individual owner couldn't be used to satisfy that judgment. So having the real estate in an entity is extremely important. Discovering your business interests. If I were to jump online right now, if you'd created a corporation or an LLC and it's set up in any particular state other than one of the states that offer anonymity, well, I would know that you're associated with that business. Now, in certain instances, we want people to know that. That is, I operate under Anderson Law Group and Anderson Business Advisors. it wouldn't be in my best interest as a business owner for this particular type of business to hide my affiliation with Andersen, because it may call into question whether or not I truly work for that company. So I do a lot to tie my name back to Andersen for marketing reasons, for overall exposure in the marketplace, so that people know that Clint Coons, they associate with Andersen Law Group. I wouldn't want to be hidden in that context. But in other entities and endeavors that I'm involved with, I absolutely want to keep those ownership and my business affairs private. That is, I think there's 17 different entities I've established that are, of course, I'm somewhat associated with, either as a member, a manager, an officer, or director. And of those multitude of entities that I've set up for myself, there's only a handful, actually I think there's 2, that you could trace back to me, to my personal name, because I've adopted the strategies I'm going to share with you this evening to protect all of my assets so that those entities remain private and they're not out there in my name. Protecting your personal property. Okay, you can find out what somebody has, such as vehicles. They're in your personal name. And this can be a problem, or bank accounts that are in your personal name. You make these extremely attractive targets, again, for a creditor, or not even a creditor. Think of it in terms of people who are trying to steal your identity, because that's equally important now in this day and age, that identity theft is a huge problem. I myself have been a victim of that in the past, where somebody had obtained my identity. And the only way I found out about it was that when I went to apply for a loan for a piece of property I was purchasing, it torpedoed that loan because of what this individual had done. And it took me a considerable amount of time to fix my credit as a result of that. Now, this all stems from having information that's available in your name. Now, I'll give you a couple examples of one example of personal property, why it's so important, and one with regards to bank accounts. Personal property, we're going to take vehicles. About 2 months ago, one of my employees in my office here in Tacoma, Washington, was contacted by an individual at her personal residence. It is Saturday morning. She wakes up. She goes, here's a knock at the door. She goes to the door, and there's somebody standing there demanding that she provide her 3 cars, and a boat, and an RV trailer. This is our 5th wheel. This person said, I want all my assets. Now, my employee said, what are you talking about? These are not yours, they're mine. She said, oh, no, absolutely, these are mine. Look, here are my registrations. And sure enough, this person produced registrations for all of my employees' vehicles. What she was able to do is obtain the information on these cars and vehicles. And what's unfortunate here is that the Department of Social and Health Services provided this information because this person had the same name as my employee. And because she had the same name, she was able to get this information. She then logged on to the website, the DMV, and she changed all the registrations online over to her address in Eastern Washington, and then went to my employee's house and demanded that she turn over these vehicles to her because she owned them. Now, this was extremely frustrating. Of course, my employee came in. She's like, here's the bill of sales. She didn't know what to do. She said, here's this person trying to steal my vehicle. She called the police. The police said there's nothing they can do about it. She had to work it out on her own. So she felt trapped. She called the DMV. The DMV said she had to change everything back in her own name, and it was going to cost $800, and it was my employee's financial responsibility to do that, when it was the DMV themselves and DSHS which gave this individual this information and allowed them to go out there and transfer the registrations into their own name. Well, she paid it, and we got it out of her name. I'm going to show you how we did that, so this will never happen again. But the point is that you may not understand how this all works because you haven't been exposed to it before. You think, can somebody really do that? Well, absolutely. Depending on your state, they could. In Washington State, where I reside, all you need is the VIN number and the person's last name, and you can log into the website and you can change everything, all their vehicles' registrations, to whoever you want if you have those 2 pieces of information. That's scary when you think about it because there's no checks and balances there. Now, with bank accounts, the problem with bank accounts is that when they're in your own name, if somebody gets a judgment against you, and sometimes judgments, happen where you don't even know about them. That is, they get what are called default judgments against you. You're never served. They make false representations to the court that you were served, that they published notice because they didn't know where you lived. And then a judgment's entered against you. They find out where you have an account, and then they will go down, register that judgment, and get a lien against your account. Now, with a bank account, what's scary about that is when you file a lien, actually it's what's referred to as a garnishment, you get a writ of garnishment. When I file a writ of garnishment against your bank account, the bank will hold all the funds for me as your creditor. And you will be then locked out of your account. You'll no longer have access to those monies. So if you keep a lot of money in your own name in your personal account, this is something that is significantly at risk for these default judgments that you were never aware of, and all of a sudden now your money's locked up and you have to go back to court to try to get it back. So that's a problem as well. When you keep your bank accounts in your own name, you make it very easy for creditors to lock that cash up because the bank will then hold it for them under that writ of garnishment. So the more you show, the more you could owe is the way I look at this, is that the more you keep in your own name and the more you keep exposed to anybody who's out there looking around, you're giving them the opportunity then to take that from you. So privacy is really important, and we can protect things if we go about it the right way. So we have a couple options. You can set up your business in a state that offers what I refer to as nominee protections. The nominee protections are protections that are set up to mask the ownership of that entity. That is, we do not disclose who the officers and directors are, who the manager is of an LLC, or who the members are in a limited liability company, because the state has specifically crafted their statutes so that this information is not publicly available. Now, some notable states you're probably very familiar with would be Nevada and Wyoming. They offer nominee protections. Some states don't even collect the information, so there's nothing to provide someone if they did go looking. Say New Mexico is a prime example of that. The intent behind these various statutes is that the states themselves want people to come and incorporate there, to set up their businesses there. And one way to entice them to do that is to provide a very favorable state or very favorable laws from the aspect of privacy and asset protection. We are pretty strong when it comes to Nevada. That is, we recommend that state a lot for these types of protections, and there's a few reasons for that. Number one, Nevada has the best statutes on the books when it comes to asset protection for limited liability companies and charging orders. Another reason is that we have a significant presence in Nevada, that when you create a business entity there, and this goes back to what I talked about with the business address again, you want to make sure that if you're going to set up a business in a state such as Nevada, that you have a local business address in that state. That is, it's one thing to use a nominee, but if the address points right back to you, then you've lost your asset protection, or your privacy, excuse me, not your asset protection, you've lost your privacy, because we can just trace that business back to you through the address. You want the full, complete package, that when you're utilizing this type of protection, the privacy aspect, you don't want your name associated with the entity, nor do you want to have your personal address associated with it. And it's always a good idea, too, that if it's a Nevada entity, you're going to want to have a Nevada address, not a P.O. box in your state, because then that calls into question where that company is truly conducting its business. Now, when it comes to holding real estate or personal property, I suggest that you use trusts. They offer great privacy. They may not provide asset protection, but will utilize business entities for that, and I'm going to be drawing that out here in a second. But the trusts themselves can be created in such a manner where your name does not appear on title, so that we come up with a trust name. It doesn't have to be filed or registered with any state. You can decide your own name that you'd like to use. Many times when it comes to real estate, I'll use the property address, but you're free to pick anything you want. And then you create this trust, and as long as your name, it's not registered anywhere, your name can not be associated with it, you have privacy there, and we'll be getting into that. You could also create holding LLCs to hide ownership. That is, if you have multiple LLCs that you've created in several different states to hold your various business or real estate, and they're currently structured in that manner, well, most likely your name's associated with that LLC. If you're the manager or you're the member in that LLC, each and every year the state requires that you provide them with an updated manager or member list. Well, the way you protect yourself in that matter so that your name is no longer associated with that entity, you'll set up a holding entity, such as the Nevada LLC, and make it the member in all these various state-specific LLCs. So when you supply the information on an annual basis to the states in which your companies are set up, you will be providing them the Nevada LLC's information. And through a use of a nominee officer or nominee manager associated with that Nevada company, that Nevada holding company, your personal interest in that company will then become private. That is, if somebody looked at the LLC, for instance, that was set up in Idaho, and they wanted to know who the members were in that LLC, it would then point them to the Nevada LLC, which is filed with Idaho as the member. They would look at the Nevada LLC online, and they would see there's a nominee manager there, an individual whom we use in our office named A.T. Mathis. He's one of the partners in the firm. His name would be associated with that entity, and it would say nominee after his name. Nowhere in that chain would your name appear if it's set up properly. Now, you may make a mistake and utilize yourself as a resident agent on your LLC. Again, you've destroyed your anonymity because we can protect the members. We can hide your management interest through this scenario. But then again, where people will mess up is they'll use their personal address. They won't use a P.O. box for the business entity, and then they'll list themselves as the resident agent. So one way or another, I can associate you back to this company. So it's really important as well that when you're creating business entities, that if you want privacy, do not list yourself as a resident agent. Utilize a company. I mean, Andersen provides this service to our clients. We're listed as a resident agent. So again, if somebody's looking at the business, if it's set up properly, they cannot tie that business back to our clients because our client's information is not associated with that company. All right, so let's talk about some of the specific tools. I'm going to start off first with the personal property trust. What is it? Well, the personal property trust is a trust that is established to hold, of course, personal property. Bank accounts, vehicles are common examples of assets that we would place inside of a personal property trust. The personal property trust does not offer asset protection. In fact, it doesn't get filed anywhere. It's just a simple revocable trust. It's a grantor-style trust that's created with one intent, that is to hold these types of assets. Now, when you go about creating the trust, it's simply a matter of coming up with a name, having a trustee, and having some beneficiaries. So let me use the example of my employee and the problem she faced with these vehicles. When she owned these vehicles in her own name, let's say her name is June. June owned the cars in her own name. So it said June is listed on the registration. Well, we wanted to remove June's name from the registration because this other nefarious individual was out there trying to take over possession of her vehicles. And so what we did is we created a trust. And let's assume we called it the Red Brick Trust. We created the Red Brick Trust, and we put June down as the trustee of this trust. Or you could actually use a nominee. A nominee is someone who serves as the initial trustee for filing purposes only and then resigns their position, and then the individual that is who's setting up the trust for, such as June, becomes the new trustee. For example, if June wanted to, she could have myself, Clint, serve as initial trustee of her trust. So we would create the Red Brick Trust, Clint Coons, trustee, dated May 1st. Now, when this trust is set up, we will then transfer the assets, that is, we would change the registration on all of her vehicles to the Red Brick Trust. Now, depending on whether or not they require the trustee's name be added, okay, that depends on the county in which you're transferring assets. Some counties do not require the trustee's information be disclosed. That's fine. If they don't, then you don't need a nominee trustee. If they do, then that's where I would be serving as your trustee. So we transfer the assets into the Red Brick Trust so that on title now with the DMV, she is no longer listed as the owner. So this other person who's running around out there named June with the same name, if she went to the DMV and tried to transfer these titles again back into her own name, she would have to know who the current owner is. And if she said, well, June's the current owner of these vehicles, and I have their VIN numbers now as well, well, it won't match up because June is no longer the owner, is no longer associated with those assets. Those vehicles have been transferred into the Red Brick Trust. And so this person would need to know that. And they wouldn't be able to know that because they wouldn't be able to find that information because it would no longer be available to her because she's not associated with those assets. So the personal property trust works great from that standpoint to keep your affairs private by putting your personal assets into the trust. So if somebody else went out there, or say a creditor was looking around to see what vehicles you may own that are trying to find assets in your own name, if they got this information, it would not tie it back to you. So that's a great trust for that. Bank accounts, another thing as well. You can take your personal bank account. This isn't for business bank accounts. This is for personal bank accounts is how I would use it. And put your personal bank accounts into the name of the trust. Many times people put their personal account into their living trust. Now the problem with that is when we create the living trust, we're utilizing our own name on that trust. So for example, the Coons Family Trust dated December 3rd. Well, there isn't any anonymity there. My name is still associated with it via my last name. So an alternative strategy maybe for my personal account is to put it into the Stonewall Trust. So I create the Stonewall Trust, and that's how I hold title to that account. So if somebody had a judgment against me and they wanted to execute with a writ of garnishment on my personal accounts, they'd be hard-pressed to collect any funds because all of my funds now are held in trust and they're no longer in my name. So if they went to various banks, which they thought that I might have an account set up with, and they filed it under my name, well, the writ wouldn't attach to the account because the account is not in my personal name. It's in the name of the trust. So that's great about one great aspect of the personal property trust, again, to keep your liquid assets, your personal banking accounts information private. So the personal property trust, as I put on the slide here, is not recorded, and it is ideal for vehicles, business interests, or bank accounts. Let me talk about the business interests here. You may not be aware of this, but you're not using a holding LLC. Let's assume they created a limited liability company in Oregon. And Oregon asks for me to disclose who the members of that company are on an annual basis. So if I'm the member in that Oregon LLC, each year I have to put down Clint Coons, member of this LLC. So I don't necessarily want that information made public. I don't want people to be able to go on the Oregon Secretary of State's website, type in my name, and see that I'm associated with these multiple limited liability companies. So instead of holding it in my name, what I will do is I will create my own trust. We'll call it the Spotted Owl Trust. So I create the Spotted Owl Personal Property Trust. And I then assign my LLC interest over to the Spotted Owl Trust. Now, next year, when I record that interest or fill out the annual renewal with the state of Oregon for the members in this LLC, I am no longer listed as a member in that limited liability company because I've removed myself from being a member. And what I've done is I've put on the Spotted Owl Trust. So that information will get listed with the Secretary of State. It'll say the Spotted Owl Trust, Clint Coons is no longer associated with it. So if somebody typed in my name to see what I own, well, as you notice, Clint's no longer a member in that company. It's a Spotted Owl Trust. And the personal property trust is not recorded anywhere, so it's not as if they could jump then and go to a different database, look up the personal property trust, and find out that you're a beneficiary in that trust and you're possibly a trustee in that trust. So they say, oh, we know what's going on here. Clint created a trust, and now he's holding his interest in that trust. It's preferable, of course, if you do this at the outset of your planning. That is, when you originally create the entity, use a personal property trust so that your name never appears. Because some states, they make they make all annual filings available to the public, so that if you went in and you searched somebody's name, you may not show up as a current member, but you could pull them as a prior member in that LLC. So if you do this from the outset, you know going forwards that you're always going to stay out of any public database record as an owner in that particular business entity. So the personal property trust works great for that, for business interests. And I'm doing that more and more now for people who desire privacy and they're not yet ready to utilize a Nevada Holding LLC. But remember, the personal property trust does not solve any problems with asset protection. That is, if your state does not have great charging order protections, this is just a smokescreen. If you are sued as an individual, they get a judgment against you, they could possibly take your LLC from you unless your LLC is protected with great charging order protections, and that comes via state law. So again, this is just from a smokescreen standpoint. So here's an example of what we would do. If I had a LLC that I'd set up right here, I would create this trust over here, and I would be the trustee. Okay, I'm assuming that I'm married, so that I would have myself down here and my wife as the beneficiaries of this trust. So in turn, I would take my LLC interest and I would assign it over to the trust. So you fill out an assignment letter in order to transfer that over. Actually, I just did this one this morning where I assigned someone's interest over to a personal property trust. It's an irrevocable assignment where we transfer over the LLC, so the LLC is now held by the trust. And so as the trustee, I direct the trust, which in turn directs the LLC in this manner. So this is one way in which to hide the ownership in your business interest by utilizing this PPT. Now the same thing would go with vehicles. If you had a car here, what you would do is you'd create your trust and you would then move the vehicle over into the name of the trust. And so now it kind of looks like a baby carriage, but you get the idea. Now I'm the trustee, so I have the right to operate that vehicle. In fact, in your trust, you say the beneficiaries would be the ones that can operate and drive the cars, and they would be insured as well. So the personal property trust would be a great option to protect your cars, and this is what I said I did for one of my assistants here in my office. All right. So real property. Now, in order to protect real property, we're not going to use a personal property trust. We're actually going to use a land trust. Now, many of you on this call, I'm sure, are familiar with the topic of land trust. That is, if you're working with us and we've created any plans for you, one of the entities we most likely set up for you in protecting your real estate was a land trust. A land trust is similar to personal property trust, if you're not familiar with this term. It doesn't provide any asset protection. It's merely a title holding vehicle. Some states recognize it by statute. Most do not recognize this. You fall under the common law when you create this trust, just like you do with the personal property trust. And with all trusts, when you go about setting them up, you're free to come up with any name you'd like for the trust. You're not constrained by, are there similar names out there set up by somebody else, like you would if you're setting up an LLC. Now, the reason why we want to use land trust for real estate is that when you take title to property, if you're taking title in the name of an LLC, which offers you the asset protection, your name is associated with that LLC. Of course, there's no privacy there. So if you set up the Forest Green Limited Liability Company, Clint Coons as member and manager of this company, and it went out and bought a house, well, if somebody looked at title to that property, they would know that it's owned by this Forest LLC, and they would know that the Forest LLC is held by Clint Coons individual. Now, the LLC provides asset protection, but by disclosing that information, you still are giving a creditor another advantage if they were coming after you individually, because now they know you have assets. Now, the LLC may protect those assets, but an aggressive creditor also appreciates the fact that he can tie your assets up to an extent, and that there's a hassle factor there that you're probably willing to settle out for in order to make that case go away. And given that I have that information now, I can probably push that settlement figure up a little higher than I would expect to get if I didn't think you had any assets. So keeping your ownership private is one way to go by utilizing the land trust, that is the ownership of real estate. Moving into a land trust first before dropping that into an LLC. So the way the privacy works with the land trust is similar to the personal property trust. But in many cases with the land trust, you will utilize a nominee trustee unless your accounting allows you to file without including the trustee's name. And the easiest way to do this is just call the county. For example, we probably set up, I don't know, maybe 75, 100 land trusts a month, quite a few. There's been a big change in the last several years over people looking for privacy and utilizing land trusts not only for this but for tax purposes, that is moving assets in and out of entities. Some states or some counties will actually tax those transfers, and one way to get around that is utilize the land trust. And I'll show you that here, and I'm going to draw that out. But so tax issues are important, privacy is important with land trusts, due on sale clause. With lenders, it's another important reason why you'd want to use a land trust, because a land trust exempts the transfers by moving it first into the trust. So there's several compelling reasons why this trust should be established. Now, when a client asks us to set up a land trust and they're looking for privacy, before I register that trust, if they want me to serve as a nominee, I'm going to call the county where the property is located. I said register the trust, excuse me, I mean record the deed, is what I meant to say, before I record the deed into the name of that trust. I'm going to call the county and I'm going to ask them, do you require the trustee's information be listed on the deed? That is, if I set up the XYZ trust, do you require that when we record the property from John Doe into the XYZ trust that we list the trustee's information as well, or is it sufficient if all we do is list XYZ trust? Now, there's a handful of counties out there that do not care. They'll tell you, you can just list the trust name. Now, they may ask you to provide them a copy of the trust for their records that's not made available to the public, so they have this information. Other counties may require that you actually give them the trustee's information. So if that's the case and they're requiring that you provide them with the trustee's information, now we have a problem. That is, if you're going to serve as the trustee of your trust, then you've lost the anonymity there. So what you want to use is someone like myself, an attorney, to serve as your trustee. And I'll explain that a little later, why it's important you use a trustee or an attorney. So if we were transferring title now from your name into this XYZ trust with Clint Coons, or we were taking title initially in the trust name, what would happen is the trust would then be listed as the owner. So it would say XYZ Trust and possibly Clint Coons as trustee on title now for your property. So now if you can see that if somebody looked up this particular asset and they want to know who the owner was, you're no longer listed as the owner of that property. It's listed in the name of this trust in the care of a trustee. Well, if you're utilizing a nominee trustee such as myself, obviously I'm not going to want to stay on that property, and you're not going to want me to stay on as trustee, or you may. I don't have the control of selling or encumbering the property. The trust agreement prohibits that. But in most instances, what we'll do is I will resign my position as trustee. And when I resign my position, you're already set up. That is, you as the client, you're set up in the trust agreement as the successor trustee. So you step up and you now have immediate control over this trust as the trustee. But anybody who is sniffing around trying to determine what you may own will not be aware of this resignation and your subsequent ascension to the position of trustee, because that information is not recorded. That's a private document that you keep with your trust documents. So if you have to put on the trustee's name, then I would suggest you use a nominee trustee. If you don't, because you've contacted the county ahead of time, then there's no reason to go through all that. Just use your own name as the trustee. Now, a couple things, one thing that I do want to impress upon you is that if you are utilizing a land trust in this manner that does not require that there be a nominee trustee, that is, you do not have to list the trustee with the county, Keep in mind that when you create your trust, if you're doing this on your own, you do not want to be in all three positions. That is, as the grantor, trustee, and sole beneficiary. You have to have another party involved. You know, you and your spouse could be the beneficiaries of the trust, and then one of you can be the initial trustee, the other one would be the successor trustee. You're both going to be the grantors, assuming that you own the property because you're the one transferring it in. You have to have some change in that chain there. Otherwise, the transfer, and this is purely from an asset protection standpoint, the transfer would not be effective for asset protection purposes and would merge back into your name if somebody came after you. So that's an important concept that you should write down if you're thinking about doing this on your own, that you cannot be in all three positions by yourself. You have to have at least one other party involved there. But the land trust, again, will get the real property out of your name. So keep in mind, standard practice, you know, use a property address and the name of the trust for simplicity. This is something I've learned over the years. When you have multiple pieces of property, you forget which property is held by which entity or which trust. The way you solve that is you use the trust or use the property address for the name of the trust. That keeps it straight for you. Do not list the trustee in the deed, just trust name. That's only if your county will allow that. Otherwise, you have to use the nominee. And last but not least, do not assign your trust interest to an LLC until all recordings are complete. In fact, some counties, assessors will ask for a copy of the trust after you record the deed. It's not that it's going to be on file, for public consumption, but they'll want to have it for their individual file that's kept private. And I've had clients who have attempted to set these structures up on their own, and what they'll do when requested for a copy of the trust, not only send them the trust, but they'll send them the assignment forms as well with the deed. And then the county will come back and say, well, wait a minute, who's this? What's this assignment for to an LLC? If your county charges a tax for any types of transfers into LLCs, then you'll get hit with that assessment at that point in time. So it's best that you only provide what is asked. If they ask for the trust, you only provide them a copy of the trust, and then you assign it later over to your entity. Whenever you're dealing with land trusts, you're dealing with county recorders, you're dealing with banks, something to keep in mind that if your title's held in the name of your trust, you need to consult with either our group or somebody else that's familiar with trusts before you respond to any information requests. Because inadvertently you can sometimes provide too much information, more than what's been requested, and as a result of that you create more questions and create more problems for yourself because the person on the other end does not understand what it is they're looking at. Last Thursday, one of my clients called me panicking. They're trying to close on property in Florida with a trust that I created for them. And these individuals happen to be Canadians. And the problem they ran into is the attorney who works for the bank in Florida stated that you could not close. They could not close in the name of the trust because it was his opinion that under Florida law, the trust had to be recorded, number one, that the beneficial interest in the trust could not be held by an out-of-state entity because we had the a Nevada entity owning this land trust, so that has to be registered in the state of Florida, and the trust needed to have an EIN. The problem with this scenario is, number one, the attorney doesn't know what the heck he's talking about, so you're going to run into a lot of ignorant attorneys and professionals who have never dealt with this, or they've dealt with this in such a limited, their experience is so limited that they're always going to resort to these types of tactics in dealing with it to recover themselves. Or the client, which is another problem in this case, provided too much information. Because when I set this up for my client in Canada, I gave him I set up the Nevada entity, the land trust, gave him the assignments, said don't do anything with the assignments until after the property's been recorded into the name of the trust. Well, of course, the bank called them directly, asked for information. My client sent it right off. They did not talk to me before they did that. So the bank not only got the copy of the trust, they got a copy of the assignment over to the Nevada entity. They should have never had that in their hands. Now they had it, so that created additional questions. We were able to fix the issue, but the problem is too much information was provided. It was not set up the appropriate way at the outset, that is the disclosures, so that we wouldn't run into this. And closing was actually been held up by a week, and it won't take place until this week as a result of that. So be careful when it comes to dealing with these entities and what type of information you provide to other parties. So quite simply, the way it would work is that if you already have real estate, you set up your trust just like this. And again, use the property address. So we'll call it 732 Broadway Trust. And I'm right here, and my wife's here. Then we will be the beneficiaries of this trust over here, and I will serve as the trustee. We will then deed this property into the name of our trust. At this point in time, we've removed ourselves off of title, so we're no longer listed as the owner of this property. It's held in the name of the trust, which we control. But there's no asset protection here. Okay, this is just a smokescreen. As I started off this webinar talking about, we need to still protect ourselves. So what we'll do here is we'll create a limited liability company right there, and we will move our trust into the LLC. So we'll sign our interest over. We're the members of the LLC. Now the trust is held by the LLC, so if something happened here, we're protected. That is, they couldn't sue the trust and then get us individually, because the LLC acts as a shield. Another benefit of setting it up in this manner is that if you have an LLC set up here and you have a few land trusts that you've created owning real estate, and this is a client of mine down in Las Vegas that I'm working on right now, we had 3 properties set up initially in one LLC. We've now created a second LLC, and we want to move this one over to here. Because they're set up in land trusts, we do not have to deed the property. All we will do is transfer the trust to my client, who will in turn transfer the trust into the new LLC number 2. So there's 2 assignments. Assignment from LLC number 1 to client, assignment from client to LLC number 2. So this property is no longer owned by LLC number 1, it's held actually over here now in LLC number 2. That information is not recorded anywhere. No one knows about this transfer because we're transferring a beneficial interest in a trust that does not get recorded anywhere. So it really simplifies property transfers, doesn't alert anybody to the fact that we're moving assets around. Now the last thing I want to talk about is business interests. When you set up a business interest or a business, you can mask your ownership, such as your ownership in multiple LLCs, like I talked about, by using a holding LLC in Nevada where you utilize a nominee manager. The nominee manager is someone who is listed with the Secretary of State when the entity is filed. So if I created the Privacy LLC, as I call it, I created my Privacy LLC in Nevada. When I file that document, I have to list the manager of the LLC. Nevada says, who is the current manager of that LLC? Well, we use an individual in our office, my partner, Toby Mathis, and we use his initials, A.T. Mathis, and after his name, we list nominee. So we let the world at large know that Toby is serving as a nominee manager only with respect to this entity, and that he is resigning. But the client who is becoming the subsequent manager, that information is kept private. We do not have to disclose that because Nevada does not ask for that. So when the LLC is set up, Toby's listed initially as your manager. Then he resigns right after the filing is complete, and the client is listed as the successor manager, and the client takes over. So this Nevada LLC will become the sole member of all of your other LLCs that are created in different states. So each of those LLCs in turn will point back to the Nevada LLC to mask the ownership in those companies to keep your affairs private. That's what we mean by holding LLC. And what it looks like is this. Let's say I have an LLC in Idaho, I have an LLC in Washington, and I had an LLC set up in Oregon. Well, rather than put Clint on here as the member, and record this with the Secretary of State on an annual basis, I list this Nevada LLC as my owner in each of these companies. And I'm down here as the owner in the Nevada LLC, and I'm up here as the manager. So I'm the manager and I'm the member. None of this information is made available to the public because Nevada masks it through a nominee manager. So if somebody was inquiring as to who's involved with this entity, what it would do is it would point them down to here. And this is where they would see A.T. Mathis. And your name would not be associated with it. So a holding LLC works great. Not only do you get this nominee protection there so that all these entities now are kept out of your name, but it also provides an additional layer of asset protection. So if I'm sued as an individual at this level, these companies up here are all protected because this Nevada LLC offers exceptional protections that you're just not going to find in other states. Well, I mean, there are a few states out there that come really close to it, but by and large, most states do not offer the same protections that a Nevada LLC offers. So that's an added benefit. And remember, here you're going to have a business address in Nevada. You want to use a business address there. You don't want to have your name on there or your personal address. Otherwise, this is not going to work for you. So we want to keep the addresses off there as well. And many times when I create an LLC, let's say I was setting up an LLC in Oregon, I will inquire as to whether or not I have to provide a local Oregon address for the business address. If they do not require that, then what I'll use is my Nevada address down here for my Oregon company. And that way I keep, my personal address off there. Or if you're going to have to use a P.O. box. Now, what are some concerns in adopting any type of anonymity with regards to your affairs? Okay, because there are some costs of doing this. Number one, okay, do not use your personal address on the business entity trust. I talked about that. That's something we want to stay away from. You got to use a P.O. box. Use an attorney as a nominee for your business or your trust. If you're going to utilize someone to serve as a nominee, officer, director, manager, or as a trustee, make sure that person is an attorney. Here's why. Several years ago, a client of mine in New York decided to utilize a really good friend of his, a fellow real estate investor, as his nominee trustee on his land trust. And see, their deal was this. You serve as a trustee of my trust, and then I'll help you out with some of your trusts as well. So they can't tie the properties back to us, the properties that we own. Well, the individual he was using decided to quit paying his taxes to the state of New York. So what New York did in turn is they came in and they filed liens against every property where this individual's name appeared. Well, because they set up their trust with the nominee trustee, that is, Joe used his buddy Frank as his trustee, and Frank had several $100,000 in tax liens, the state assumed that every trust that had Frank's name associated with it held assets that belonged to Frank. So my client Joe had to fight the state to get these tax liens removed from all of his real estate held in these various trusts. And it was very expensive because the state assumed that maybe Frank and Joe were in collusion and trying to pull a fast one to save Frank's assets from the state's garnishment action. But they won, they were successful, but it came at a tremendous cost. And so by utilizing an individual, if you're going to utilize a friend, you're not going to utilize a professional, make sure you really know that person. I mean, you never really know somebody, but there is that risk. I think it's best to use a professional, utilize somebody, again, in a different state to serve as that trustee, just to make it even more difficult for individuals to track that through. And then, of course, the nominee resigns. Now, I put down here, do not use a nominee if establishing business credit. Now, here's something where you would never want to use a nominee because this will work against you. Number one, I already told you if you're out there and you want to be associated with the business, don't use a nominee because that's going to disassociate you from that and then raise questions in a prospective consumer or customer's mind as to your veracity in your business dealings with them because they can't tie you back to the business. I mean, if I'm going to do business with somebody, many times I'll Google them and see what type of information I can find out about them and their associations with the company they purportedly represent. If I don't see anything there, that does concern me. So that's number one. Number two, the issue has to do with obtaining credit. If you have a business that you want to obtain loans through or build a business profile through, anonymity is not good in this instance because it will work against you. You will not be able to establish that type of credit. You won't be able to get loans necessarily in the name of the business unless your name appears on there, because the banks, when they see that and it goes through underwriting, they will then back off from that and say, wait a minute, you told us you want to buy it in this business entity, your name doesn't appear online. Yes, you've given us paperwork showing you're the owner, but when we pull this up on the Secretary of State's website, you're not associated with it. So how do we know that this is your company and you just haven't printed off some operating agreement and sent it to us for purposes of obtaining this loan? How do we know you're not trying to do this for somebody else? That's a real problem. So do not utilize any type of privacy strategies when you're involved in those two situations that I just described. And then the last concern I have is, when it comes to nominees and anonymity, this isn't something you should really attempt on your own. Utilize a professional. There's just too many steps or too many transactions along the way where you can make a misstep and create problems for yourself. I try to make it as simple as possible when I'm describing it, but there are a number of filings and there's certain orders to things that you must strictly follow to ensure that it's done in the proper sequence. Otherwise, you could create problems for yourself down the road. So other than that, follow these rules, and you can find that you can protect your assets, and you can hide your information from anyone that's coming looking to see what it is that you own. And in the future, it'll be on a need to show or need to know basis, not on a need to show basis. My name is Clint Coons. I'm an attorney with Anderson Law Group. My contact information is there. Should you have any questions about this, feel free to give me a call. I'd be happy to answer those questions. You can email me as well at ccoons@alglaw.com. Just please, when you're contacting my office, make sure that you reference that you were on this webinar so I know what it is that we're talking about if we set up a conference call, and I know what your questions would be referring back to. But other than that, I wish you all the best with your asset protection planning,